Hello and welcome back to LiveLaw Daily. I'm Debojit Das. Today is August 21st, and on this day in 2006, India lost one of its most celebrated classical musicians, Ustad Bismillah Khan. The legendary Shehnai maestro and Bharat Ratna awardee is remembered for taking the Shehnai from traditional performances to the classical concert stage, and for his historic performance from the Red Fort on India's first Independence Day in 1947. And on that note, let's take a look at the biggest legal developments making news today. For our first story today, the Supreme Court has set aside a Madras High Court order directing the trial court to summon the Union Telecom Secretary as a court witness in the criminal case against DMK Member of Parliament and former Telecom Minister Dayanidhi Maran concerning alleged misuse of BSNL facilities. So what happened? A bench of Justice KV Vishwanathan and Justice Arun was hearing the CBI's challenge to the High Court order. The Supreme Court has now restored the trial court's earlier order, which had refused to summon the Telecom Secretary as a court witness. But there is an important qualification. That is, the court has given Maran the option of summoning the Secretary as a defense witness if he chooses to. The issue came up earlier on August 10th, when the court asked the CBI whether it would object to the secretary being examined as a defense witness. Additional Solicitor General S.V. Raju said on instructions that the CBI had no objection. But senior advocate Siddharth Luthra, appearing for Maran, argued that the secretary should be treated as a court witness because he could explain the rules and administrative procedures applicable to union ministers. The Madras High Court had earlier held that the Telecom Secretary could clarify the administrative framework governing such facilities. It had also noted that the prosecution witness Rita Achari had spoken about the general policy applicable to union ministers, but not specifically about the minister heading the department. The CBI's charge sheet alleges that Maran, in conspiracy with senior BSNL officials and persons associated with Sun TV network, obtained and continued to use a large number of telecom facilities at his residences in Chennai and Delhi. The alleged facilities included hundreds of telephone lines, ISDN connections, broadband and leased circuits, and other telecom infrastructure. The prosecution alleges that this caused a wrongful loss of about 1.78 crore rupees to BSNL and MTNL. For now, the Supreme Court has restored the trial court's order while leaving Maran free to call the Telecom Secretary as a defense witness. And for our second story, the Supreme Court has disposed of 3 petitions concerning the controversial film The Kerala Story while leaving an important question of law open. A bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi, and Justice V. Mohana heard the matter today. One petition filed by producer Sunshine Pictures was withdrawn. In the other 2, Advocate Nizam Pasha argued that issues still survive even though the film has already been released. He pointed out that the Kerala High Court had held that a writ petition cannot be maintained against the CBFC's certification of a film. Pasha argued that while the producer has a statutory remedy, other persons aggrieved by a film may have to approach the High Court. Justice Bagchi said that the legal question could be left open, observing, the litigation has to await another movie that is controversial. We will go into that question. Pasha also sought guidelines for films that promote hate speech. The Chief Justice of India responded, "Alright, file a comprehensive writ petition seeking general guidelines." The court has therefore recorded that the question of law remains open with liberty to initiate appropriate proceedings. The Kerala Story, directed by Sudipto Sen and produced by Vipul Amrutlal Shah, had attracted controversy over its claims regarding women from Kerala being converted to Islam and recruited by ISIS. The Supreme Court had earlier stayed West Bengal's ban on the film. So while these petitions have been disposed of, the larger questions surrounding CBFC certification, judicial remedies, and hate speech in films remain open. For our third story today, the Supreme Court has ordered the premature release of a 105-year-old convict named Rasik Chandra Mondal in a 1988 murder case. A bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi, and Justice V. Mohana passed the order today, making his earlier interim bail and parole absolute. Mondal was booked by the West Bengal police in 1988 and was convicted under Section 302 of the Indian Penal Code in 1994. His appeal was dismissed by the Calcutta High Court in 2018 and his challenge before the Supreme Court was also unsuccessful. Mondal then approached the Supreme Court in 2020 when he was 99 years old, seeking premature release. In 2024, the court had granted him interim bail and parole while his plea for release was pending. Now, taking into account his age, the Supreme Court found no justification for keeping him in prison for the remainder of his sentence and ordered his premature release. So, at 105, Rasik Chandra Mondal will now be released from custody. For our next story today, the Supreme Court has modified the rules for entering the judicial service, at least for the next few years. A bench of Chief Justice of India Suryakant, Justice Augustine George Massey, and Justice K. Vinod Chandran, who dissented, has waived the 3-year practice requirement for Civil Judge Junior Division examinations notified between May 20th of 2025 and March 31st of 2027. So, law graduates during this transition period can apply without prior practice. The court has said that they will be deemed to have completed 1 year of active practice and they won't need a separate certificate for that deemed period. But there is an important condition. Those selected will initially be appointed as trainee judicial officers. They will undergo 1 year of intensive training at the concerned state judicial academy, followed by 1 year of structured law clerkship. The first 6 months will be under a district or higher judicial service judge and the remaining 6 months under a sitting high court judge. The court has said that these 2 years of training and clerkship will count as equivalent to the required practice. During the academy training, trainees will also receive emoluments equal to half the gross remuneration of a judicial magistrate first class. And after the transition period, from April 1st, 2027, candidates will need at least 1 year of actual legal practice before appearing for the civil judge examination. That practice will have to be verified through a certificate. The court said that this limited intervention was required because the sudden restoration of the 3-year practice rule in its May 2025 judgment had caused hardship to law graduates who had planned their careers under the earlier system. So the 3-year practice requirement has not simply been scrapped. There is a temporary waiver for the transition period, followed by a 1-year practice requirement from April 2027. For our next story today, 97 pending cases involving murder and other serious offences have been recalled from the Court of Additional District and Sessions Judge Ravi Kumar Divakar in Muzaffarnagar. The cases were recalled through an administrative order issued by District and Sessions Judge Virendra Kumar Singh and will now be dealt with by him. The order itself does not give any reason for recalling the cases. The development comes after Judge Divakar's court awarded 22 death sentences in 10 separate cases between April and August of this year. The first came on April 6th, when 3 accused were sentenced to death in the murder of lawyer Sameer Saifi. Further death sentences followed in cases involving murders, including the killing of a home guard, a farmer, and a wood trader. The 22nd death sentence was awarded on August 13th, when 4 people were sentenced to death in a 12-year-old murder case. It's important to remember that a Sessions Court death sentence is not final. It has to be confirmed by the High Court where it can be executed. Judge Divakar has been posted in Muzaffarnagar since November of 2025. He had earlier attracted attention over his orders in the Gyanvapi case and in 2024 after the Allahabad High Court expunged remarks in one of his orders that praised Uttar Pradesh Chief Minister Yogi Adityanath. For now, the reason behind the administrative recall of these 97 cases has not been stated in the order. For our next story today, the Madras High Court has issued notice on a plea by IPS officer and former Tamil Nadu Directorate of Vigilance and Anti-Corruption Chief Arun, who wants the court to restrain YouTuber Shankar, also known as Savukku Shankar, from publishing what he says are defamatory allegations against him. Justice K. Govindaraj has issued notice to Shankar as well as Google, YouTube and X Corp. Arun has also sought 1 crore rupees and 5,000 rupees in damages, claiming loss of reputation, emotional distress, mental agony, professional harm, and violation of his dignity and privacy. As an interim measure, he has asked YouTube and X or Twitter to take down the allegedly defamatory content and has sought an injunction preventing Shankar, his followers, or anyone acting on his behalf from publishing or circulating similar content in the future. There is some background to this dispute. Earlier this year, Shankar had approached the High Court seeking a CBI probe into allegations against Arun after another division bench had rebuked the IPS officer over a detention order, observing that it had been passed for extraneous considerations. However, the High Court dismissed Shankar's public interest litigation, saying public interest litigation is not meant to vindicate personal animosity, and noted that the personal allegations he had made against Arun. Shankar subsequently made further allegations against Arun through videos on his YouTube channel. The court has now issued notice on Arun's plea for an injunction and damages. For our seventh story today, Cockroach Janata Party's Saurav Das has approached the Delhi High Court against commentator Abhijit Iyer Mitra, digital media platform Pamphlet, legal news website Lawbeat, and others. Saurav Das has alleged that his residential address and other personal information were revealed on social media and has claimed that this violates his right to privacy, dignity, and security. The suit also names Sunday Guardian, Jaipur Dialogues, Google LLC, and X Corp or Twitter, among others, as defendants. Saurav Das is seeking permanent and mandatory injunctions, along with damages over what he describes as the intrusion into and publication of details concerning his private life. The case is now before the Delhi High Court. Our eighth story is from yesterday, but it's an important development that I thought should not be left out. A controversy has emerged in the Calcutta High Court after Justice Shivra Ghosh recused from hearing former TMC Minister Sujit Bose's bail plea, alleging that an advocate for the petitioner had contacted her private secretary to gain access to the case records in her chambers. The advocate in question, who was appearing for Bose, has categorically denied any attempt to access the case file or any collusion with the court officer. She said that after Justice Ghosh reserved judgment on August 17th, she was asked to supply copies of judgments relied upon during the hearing. On August 18th, she received a call and WhatsApp message from Advocate Naheed Ahmed, a junior of senior advocate Sabyasachi Banerjee, informing her that the court officer had called her to provide those judgments. Bhoval here, the advocate in question, said that she went to court number 15 and was then taken by the court officer to the front room of Justice Ghosh's chamber. There, she says that the court officer asked a staff member to show her the case records. The staff member, however, said that the file was with Justice Ghosh and could not be shown to her. Bhoval says that she left immediately. She has specifically denied entering the judge's chamber or acting with the court officer to access the case file with any improper motive. She later supplied two judgments relied upon during the hearing to the court officer. Bhoval has now sought an inquiry to establish her version and preservation of the CCTV footage. For a ninth and final story, the Delhi High Court has restrained the directors of coaching institute FIITJEE Limited from travelling outside India without the court's permission in a dispute over unpaid rent. Justice Sachin Datta has also ordered the attachment of 66.31 lakh rupees lying in the bank account of FIITJEE's sister concern towards the alleged rent dues. The directors have been directed to deposit their original passports within 4 weeks. The order came on two petitions filed by landlords under Section 9 of the Arbitration and Conciliation Act seeking interim protection against FIITJEE. The landlords said that FIITJEE had vacated their premises but left substantial rent arrears. The dues were 33,15,957 rupees in each case, taking the total to 66,31,000 rupees. FIITJEE's counsel said that the company could not make payments because its bank account had allegedly been attached by police in separate criminal proceedings, but details of that attachment could not be provided. The landlords meanwhile pointed to an earlier case where FIITJEE's liability had been discharged through the bank account of its sister concern, FIITJEE E-School Private Limited. Taking this into account, the court ordered that 66,31,915 rupees in that account be attached, subject to further orders in the petitions. The court has also directed the directors to remain personally present and restricted their foreign travel without its permission. And that's all for today's Live Law Daily. From the Supreme Court to the High Courts, those were the important legal developments you need to know about today. You can find the links to all the stories here in the description box below. Thank you for listening.